Mr. Chair. This is Sanford Berlin, Executive Director of the Commission on Ethics and Lobbying in Government, and we're convening a meeting of the Ethics Committee of the Commission. Two commissioners present at New York State Conference Center in Manhattan, in a space that is open to the public, and in addition, Commissioner Austin, Vice Chair of the Commission, is participating remotely in accordance with the Commission's procedures for remote participation in extraordinary circumstances pursuant to Public Officers Law 103-8. Thank you.
Thank you, Executive Director Berlin. I'd like to call this meeting of the Commission on Ethics, Lobbying and Government Ethics Committee to order. So the first item on our agenda is the outside activity approval process. And we really are not really going to discuss changing anything. We just wanted to go over what the process is so that everybody on the committee can be familiar with it. But I guess I'll...
Sure, I can provide an explanation. So, we have the Attorney of the Day program whereby an attorney is assigned each day to receive all inquiries and requests for guidance that are received on that particular day. And whoever receives the request, that becomes their assigned request. That person would review the request. If anything is missing, if any additional information is needed, they'll reach out to the requester. And that person will prepare the first draft of the response. If it's a line attorney, then the letter would be forwarded directly to me for first layer of review. We prepare any edits or revisions. I would then forward it to Keith, who is the General Counsel. Keith would make any revisions or edits he sees appropriate, and the final review would then be conducted by the Executive Director Berlin. So it goes through several layers of review before it goes out, and it's also, throughout that process, there's discussion back and forth so that everyone makes sure that we're all on the same page, and if anyone spots any holes in an analysis or has any idea for anything to add in, it gets added in during that process. And I should also add that, upon receipt of the request, an entry is made in the master log. And that master log is kept updated if there's further communication between the requester and the commission. And when the final response is sent out, that's indicated on the master log with the date.
Really speaking, if I can, how long is that process? I know it depends on what the inquiry is.
Yes, we generally aim for 2 weeks. And as I've said a couple of times, we've been short-staffed and we've had a lot of work. So that period has gotten longer. And I'd say now it takes up to 3 or 4 weeks on occasion. But we are interviewing candidates for an associate counsel position and for a deputy director position in ethics. And we anticipate that when we get these hires on board, the response rates will go back up, get better.
Is there a general lead time that the inquiry is made?
No, some people, send these things in plenty of time, and some people even do it well in advance to make sure that it's going to be okay. And some people send it after the activity has already started. And in that kind of case, we can't give approval retroactively. Our approval would just be, it would apply going forward. Some people do it with a few days' notice. And in that case, when someone says that they have a real-time crunch, we do our best to expedite it, if they show the cost.
Should we let any employees know that we require require a certain advance notice?
The only problem, I mean, that would be great if we could do that, but the problem is that I think people would, like circumstances would inevitably arise where people either can't or don't comply with that, that we don't want to be in a situation where our rules preclude us from responding and providing guidance.
So can we give suggested timeframes and then say, under exceptional circumstances, we can
That's certainly
try
an
to turn
option.
it around? But I think we ought to give them some guidance so that you don't routinely get requests a week or two before.
That's not a bad idea. I mean, maybe we could do something like that, a suggested
Like
time in
ordinary
advance,
days.
or something like, right, something like that.
Advised, yeah. And so, wait, so certain people have to get both the commission and their agency and other people just.
Policymakers, right, policymakers need the approval for an outside activity of both their agency and then us.
So, okay. And it only comes to us then after their agency.
It only comes to us if the agency has approved it. If the agency doesn't approve it, then we won't review it.
So maybe you and the rest of your staff can think about what type of time frame you might want to suggest. So,
It's out versions of the actual agency, but
In the meantime,
the next item on our agenda, the Hogan-Lovells Recommendations. These recommendations arose from the investigation by the Hogan-Lovells law firm into the issues with former Governor Cuomo's book deal. They made a number of recommendations. I don't know that we should take up all of them now, but as I understand it, and I'll speak to Commissioner Austin, a couple of these items are being considered by the delegation committees. Is that right?
That's correct.
Right.
it's interesting, yeah. I'm sorry.
So item number one, which deals with activity outside activity requests by statewide office holders is something that you're dealing with, right?
Well, I don't think it won't be the delegation committee that deals with that as much as it will be the legal committee.
Number one.
that's why it's a different, this is the Hogan-Lovells.
Okay,
So
thank you.
that's it.
Hogan-Lovells will be dealt with delegation. I'm sorry.
And item two has to do with the activity request and any misrepresentations or inconsistent information that's provided, and what needs to be done under those circumstances. Is that something will also be addressing?
I believe that's correct, yes.
So this
I mean, it's very, well, I probably might be, but I looked at first recommendations that you guys made. And you know, I guess the mindset is, it's a little different because in my mind, I'm like, well, if you want to, I kind of thought it should be a little more stringent. Like if if you make a misrepresentation, but but I do like the policy that we do have, which is an open and sort of ended, and we'll keep kind of asking for information rather than. And so if you can explain the thought process that the staff has regarding that, that would be helpful to me to understand.
Well, we don't really have resources to, investigate the circumstances surrounding someone's proposed outside activity. So we rely on the inquirer to provide accurate information to us, and that's the information that we use when we perform our analysis. However, we will perform, certain simple tasks that we can do with the internet, such as checking out whether an LLC corporation has been registered with the state when someone claims that they've created an LLC. And we might just look up, say if they said that they started a small company, we might look up their website, take a look at it and see if there's anything on their website that contradicts anything that they said to us. But in the final analysis, the inquirer is responsible for providing us the information that we need. So if there are any misrepresentations, our guidance and our opinion is only as good as the information that we're given. So if there's a material misrepresentation, then
It's not good.
the opinion would be invalid.
Yeah, I thought it was a little, easy going, but like if you make a misrepresentation, it's not, like if you don't give all the information, it'll be sent back. I feel like there should be like,
Well, there may be omissions that we wouldn't know about or misrepresentations. Like, for example, just a complete hypothetical, but suppose someone says that they expect to spend 5 to 10 hours a week on their outside activity, but then later on, it turns out they're spending 25, 30 hours a week on their outside activity and their state job duties are being neglected. I think that would be a material misrepresentation, the difference between 5 to 10 hours and 25 hours, at least arguably, would be a material misrepresentation.
So, and do you think ours, like I know we have a list of the factors and that's on our website. So do you think that's sufficient? Do we need to do anything else? Do we need?
The factors essentially are that there isn't a discrete list of factors. We judge outside activity requests against the requirements of Public Officers Law 74, which deals with conflicts of interest. And there are also certain provisions of Public Officers Law 73 that deal specifically with state employees who are doing business on the side with the state. So there are those statutes that we have to be aware of, and the requirements of 74.
Okay. Mr. Carvalho, go to the next item.
Yes.
Third recommendation was that the successor agency, that being us, to document in writing the roles and responsibilities of its executive director and staff, document in writing the procedure that should be followed in the event there is a vacancy in the executive director role. Certainly something that I guess there were some gaps in the.
There was a period of time, several years, when there was no executive director.
It was an acting, dual acting executive director.
Yes, I believe so.
So this is something, do we currently have?
We do. We have detailed job descriptions for every position in the agency, including for executive director, general counsel, deputy general counsel, the various directors and their subordinates. So those are well documented. We talked about this in the special committee, and there really should never be gaps in leadership of the organization. So if there is a vacancy, really in any position, in executive,
You're breaking up.
we believe.
One day we're going to have a meeting where we're not going to have 10. Not hearing you at all.
The problem, Seymour, is we've only got 4-year terms.
Actually, I only have a 2-year term.
But what was there's.
Yeah, we
Can't hear you.
I apologize.
Let's call that for.
We're going to get that.
Michael's going to see if he can get someone to check.
In the main, may take a minute.
We got this initial. So why saying just saying, I have no trying to.
Can you hear me now?
Yes,
Okay.
kind of blurred.
Can't see you. We can hear you.
I'll use the phone audio.
Oh, okay, that would be very helpful.
Okay.
I guess I'll wait for Michael to come back.
Yeah.
Sandy.
He said he's gonna use the phone audio.
Oh, okay.
He said he hears it.
He's gonna use the phone audio. You think it might be his Wi-Fi?
Yes.
Yeah, it's probably my Wi-Fi. What I was saying was, in addition to having detailed job descriptions, we should have, and the commission would implement in the event of a vacancy. There's always been, I think in the history, certainly of Jacob, there were several periods when there was no executive director. There should always be an appointment made of an acting executive director to assume the responsibilities of the ED whenever there's a vacancy, and so that issue wouldn't arise. There was a unique situation that Hogan-Lovells is referring to where, for reasons that I'm not privy to, the commissioners declined to make a singular appointment and instead created a triumvirate of general counsel, deputy general counsel, and the chair. And there was some, I guess, uncertainty about what would happen if as did occur, one of those individuals was recused in that matter, leaving 2 out of 3 to render the decisions. I would suggest avoiding that situation by defaulting to general counsel succeeding to the role of executive director on an interim basis while a replacement is being sought. And I think that would obviate the difficulty. Or, if for whatever reason the commissioners didn't want to do that they appoint someone else promptly.
So we don't have this policy, you're saying?
Okay.
Just, never have a vacancy. Essentially, never have a vacancy. Always have a provision so that there's somebody who succeeds to those responsibilities.
So we'd have, like that's the policy.
Well, I think the argument is that aspirationally, it should just be that.
That's
It's just go through but so we should have a policy. Do we think we need to have something writing like a policy set? I think it's unnecessary.
I think that's above my pay grade.
Well, let's look at that. So maybe we ought to have, you just outlined a procedure that can be used.
Again,
And perhaps we ought to think about whether we want to institutionalize that. So that if there's ever any doubt, that we have something in writing which defines how we should proceed. Does that make sense to you, Ted? Said it without giving-
I think that can be done by resolution in terms of, documenting the procedure. I don't think a regulation or a statutory change is necessary to effectuate that.
No, okay. A resolution would satisfy the writing, so I think that would be fine. Maybe we should.
Yeah. Right.
We should draft a resolution and present it to the commission.
I was just going to try that in first.
Sure.
Okay, great.
The 4th recommendation also has to do with delegation regarding outside activity requests, and that is being considered by the special committee. So we will get that one. The next recommendation, successor agency should create a list of information and documents that must be provided in connection with all outside activity requests, including information on J-Code's outside activity approval form. This colleagues outside approval, and the underlying contract with the outside employment, including but not limited to the amount of compensation. Did we revise the form, or is it the same form?
We haven't revised the form substantively. As the form is right now, it does request a fair amount of information regarding the outside activity and the inquirer's state responsibilities. That's so we can check between the state and the outside activity for any potential conflict. We don't currently ask about compensation or a service contract unless it appears to be relevant, of course. If there's an indication of that, we'll ask about it. Or if there's an indication that compensation might create an issue, we would ask about it. But we're open to the possibility of making that like a written requirement to disclose the compensation and any service contract if there is one.
Would we revise the form to include those, and if it's not applicable, then the individual would state that? Or is there, do we want to supplement the form with?
I think supplementing the form would be fine. Just add to the list of information that's already on there.
That sound good to you, Austin?
Yes, it does.
I have one question. Michael, would it make sense also in moving the process along to have the ethics officers collect that information, or whoever's processing the agency and before it comes to us? So
Ideally, that's how it works now. I mean, ideally, the inquiry comes in accompanied by all the required information.
It goes out.
It usually goes through their ethics officer. It goes through them, and the ethics officer presumably has requested any information that they believe is necessary. But once in a while, things come through, and we want to look into it a little further.
That's not part of their.
They have their, the agencies have their internal processes. They aren't necessarily performing the exact same review that we are. I think that's the value of having this extra layer of review.
And I wasn't, so were you suggesting the agency's ethics officer or ethics officers within COLA?
Well, it would be helpful to us, and it would expedite the process if the ethics officers were, and they may not need it, so they may not be as diligent in collecting it. But I would think it would be useful if they understood what we're going to require ultimately, so they have the opportunity to look at it as well. But when the information is sent on to us, whether it's transmitted by the ethics officer or by the applicant, the more complete it is to start with, the better the view we have of the situation from inception, when we, meaning Michael's group, is first reviewing the request.
So we'll need to communicate with all the ethics officers. Sorry, we'll need to communicate with all the ethics officers.
We can do that. I should point out that it's not always the ethics officer who's dealing with it. The agency can designate anyone to have authority to approve outside activities. So sometimes it's smaller entities such as medical facilities. It's the executive director of that particular facility who will do it. So we would have to do some outreach to figure out exactly.
But do we have a list of all the agencies of who's responsible for
No.
screening these?
We don't have a comprehensive list of that. And there may be some small agencies that don't have an ethics officer.
Do we request from the agencies, name of the person who's going to be reviewing?
I mean, I suppose we could do that, and it would be great to have a complete list of just, there's
So many things you can do.
there are hundreds of agencies, and we did have a list at some point a number of years ago, and that was it arrived to us before my time here, so I don't know exactly how they collected it. But I can look into, steps that we could take to create such a list.
Yeah, we could, perhaps get some assistance from the training initiative, where we do have contacts for purposes of ethics training now with over 380 agencies. So that would be helpful in putting that together, or an outreach.
I'm sorry, how many agencies are there and how many have ethics people?
There are, in the executive branch, for training purposes, we've identified over 380
Agencies.
agencies, commissions, et cetera.
Right.
Some of them within the umbrella of a larger commission or authority. So they're kind of subsidiaries, and they may be sharing resources in some ways. But we're collecting information for training purposes from over 380 agencies.
My question really is there a way of, for those agencies that are too small to have their own ethics person, is there a way of having one person who would be responsible for 10 agencies or something like that?
I think it's a good idea.
And they may already have that. We can get with the training people and see how they've been addressing that, because they're communicating with the agencies for training purposes.
Okay.
The next recommendation pertains to establishing a standard waiting period for the approval of outside activity requests.
Staff doesn't really support that, just because every request is different, and different requests take different amounts of time to study or to collect all the information. And the process is not ministerial. It's not like you just give us information and then we check it off. We're exercising judgment, and in that case, I think we want the flexibility not to be bound by an artificial deadline that we've set in advance.
In terms of the other thing they say, is they should develop document procedures that should be followed in connection with expedited outside activity requests. So if we're going to provide them with a suggested time frame, if they don't fall within that time frame, should we have specific criteria which we look to in determining whether they expeditious?
We generally don't support creating specific criteria for this beyond a just cause. Because, I don't think we can envision all the possible criteria that might justify an expedited response. And also, we may not always be able to provide an expedited response depending on what else is going on in the agency. So I would argue that we should leave it the way it is now, where it's basically just, we do our best on a case-by-case basis when someone asks for an expedited response. We do our best to do it, and we usually do manage to get it expedited out to them.
And the statute does specify that the agency shall have a unit to provide prompt guidance, which is what we strive to do.
And then that's one of the reasons that we have the delegation.
Yes, that's right.
Yeah.
The reason we have the delegation of staff, so that it can be give the prompt guidance rather than wait for a commission.
Right.
I mean, I guess it's kind of like part of what you're looking at in the special committee on delegation. I would imagine. But at this point, the staff of the opinion, we really shouldn't specify criteria. We should use our judgment and.
That's my recommendation, rather than box ourselves in. And also, rather than attempting to identify every possible justifiable reason for an to expedite, leave it open and leave it up to your best judgment.
There was something, do you have something on that one? Yes, during JCO, there was information which was provided to certain commissioners or to the executive director or acting executive director, which they were asked not to share with the commission members. That's somewhat problematic. And so their recommendation from Hogan-Lovells is that we should adopt a rule requiring that any information provided by any party requesting approval from the agency in connection with such request must be shared with all voting members of the agency. And I see no reason why they
objection to that.
I think we should set a policy for that. It is a little bothersome that some people have information that people don't have. We're all voting on something, and we, yeah, I mean, like a written policy about that. And how do you think we should do that? Or how do you think we should?
I think probably Sandy can speak for himself, but I think the resolution would
It is the thing. So maybe we could do like a big resolution that includes several of them.
Yeah, I mean, I think a resolution is sufficient. I mean, that was a unique situation where there was information requested, and in an attempt, as I read the report, to provide that information, an arrangement was made with the requesting party that the information would be disclosed, but they didn't want it widely circulated because of concerns they had. I don't think those concerns are at all at issue with this commission. So I don't even see that circumstance coming up at all. I mean, if it were to come up, I would imagine the commissioners collectively could deal with it. They could decide whether or not they would approve that kind of arrangement. If that makes sense, you know, so it would be unless commissioners determine otherwise, all information received in connection with the request shall be made available to the full commission.
Like the resolution.
Maybe
I should say, you know, it should be on request. Typically, and I don't see this changing, you know, we have been sharing, Michael's group has been sharing guidance letters involving requests by agency heads or statewide elected officials. Those are being circulated in advance to the entire commission. Plus, you know, the alerts are in the guidance log that's provided at every meeting. You know, what's in the hopper, what's in process, what has gone out the door. Generally, typically,
Go
You
ahead.
know, when these are, we're not, we haven't been circulating the entire file. It's kind of summarized in the guidance letter, or maybe in an accompanying memo. I don't, you know, so in crafting the resolution, I guess we just deal with the fact that not every item, unless folks want it, would be accompanied by, you know, a big fat submission.
But I do think having some, you know, a resolution regarding all the information from the commission would be
Sure.
appropriate and also helpful to staff, so that they're not put in that position.
I thought of it in terms of among commissioners as well, not just staff. So I think we, you know, heard of or seen situations where a commissioner might get approached directly, you know, either then or now, and not share. So I see that resolution as being going all around. And kind of a prompt sharing of that information so
That's a
that
good idea.
everyone is on the same page. Mhm.
Yeah, well, maybe, yeah, I mean, maybe we could use a vehicle like SharePoint or something like that. So it's
Sorry.
in place that's accessible.
Would you repeat that, please, Ed?
You know, maybe we could use a vehicle such as SharePoint, which is secure. Once all commissioners, particularly once everyone on the commission has a state email address, make it easier to use SharePoint as a secure means for making information available to all commissioners.
I'd like to clarify something. We're not talking about like all information that we receive on every single like
Right,
request for
no.
guidance, right? We're talking, I think we need some kind of standard about what kind of information we're talking about,
I think you're right.
right? And I'm not sure how, right now, I'm not sure how to define that, but it's like material information should be shared, but we have to figure out what.
Right, that's right, because otherwise we'll all be so inundated, it's, you know, like everything, but you're right, like how do we categorize that?
Well, we don't don't want to always doing your job.
Right,
We
right,
couldn't, but we.
right.
That's what, trying to do your job.
Right, but yeah, I mean, you're right, like material information.
That's what I'm saying.
That one receives, maybe even outside of the actual application, right? I mean,
But not, well, we present, you know, drafts of letters regarding heads of agencies, et cetera. We should provide the request along with that and all that information. But in all the other requests that are going out routinely, you know, we don't provide that information to you now, and I don't think we need to. I mean, the letters themselves, we recite all the information that we think is relevant material in the letter itself. So,
I mean, I might sometimes want to ask, not when did you get it from your perspective, but I'm thinking about the requester, is it like, you know, you need this tomorrow, you're requesting today, so sometimes I might have, but it's not urgent or anything, I could always ask. But yes, we should have, so I guess you're probably in the best position to think about what you think.
yeah, I mean, I think this is a valid, you know, matter to consider, but I think it needs more, it needs more fine tuning.
Great, so,
You and Sandy.
Yeah, we can draft something up. I'm thinking, you know, upon request, something like that, and make it available. We'll figure out a way to phrase it.
and the other part of it that I mentioned, you know, just amongst ourselves as well.
But I think one thing that's important is that staff and commissioners be informed that any information that's provided to them, they cannot agree to withhold it from the rest of the commission.
Okay, yeah.
You could have an individual reaching out to an individual commissioner or an individual staff member
I think that is important.
and saying that, well, I'll give this information to you, but I don't want everybody else to know about it. If it pertains to the decision,
Maybe staff can't share information with a subgroup. But any information that's shared with commissioners has to be shared with all commissioners.
Yes.
Right.
Right, that's right. So it's not going to be on any staff member or commission member to have to say that to somebody. It'll be out there already. Like if you tell me something, you have to know I'm going to share it. You're calling me separately, I'm going to tell, because I have to, or there's something on me. Not that, I don't know, we don't need to go that far, of course, but I'm just saying, I like that. Right, it'll be on the form and on, but these are sometimes phone calls, so.
For outside activities, we need something in writing. We need the form.
But not, yeah, okay, this is just.
Actually, for
Yeah,
any
we're talking about.
for any written guidance, pretty much we request written in live.
Next recommendation pertains to, it's that we should adopt strongly enforced rules restricting its members from disclosing confidential information provided to them. This breach of confidentiality may undermine the agency's ability to do its job. I can argue with that.
Right.
Certainly, we need to do this, and I guess we need to written rules about it for our members.
So I have a question. I guess as we go through this, it's more like we're going to create a policy than to have just all these separate resolutions going.
Well, I was thinking perhaps what we could do is some sort of acknowledgement or statement by new members of the commission that they're familiar with the rules and understand the sensitive nature and monastic approach that we take to things, that nothing, what comes to 25 Beaver Street stays at 25 Beaver Street type of thing.
Yeah, I mean, as commissioners come on board, we do have, and all employees as well, everyone in the agency signs a non-disclosure agreement that points out those obligations. It's in the statute, of course, both in 94.7B and in 94.11, the executive law, and the code of conduct, the proposed code of conduct also reinforces that.
And Commissioner Austin, I guess your committee is working on the code of conduct, right?
Yes, the legal committee is working on that.
Basically, this actually, we have this in effect right now, actually.
Effectively, yes.
Everybody did, I remember signing.
I do remember saying I couldn't divulge anything.
I was saying, I think we are under a stricter confidentiality provision than any prior agency, maybe I'm wrong, the industry. So.
It is required by the statute. So.
The code of conduct will be different from, well, our policies sort of is a code of conduct. So I think it's going to have to be melded with the two committees working on this.
Yeah, I think, well, yeah, because he's working on the code of conduct.
I mean, I think it's worthwhile doing it both because our perspectives are slightly different and both important. Maybe it'll come from there. You guys will draft it, it'll go through the legal committee and then come back to us.
I think we can let it go through the legal committee and they should be able to cover bases that
We'll do the best we can.
That deals with four executive directors. I think we sort of discussed this earlier when we were talking about the procedure of the executive directorship. There's a vacancy, so kind of covered that.
Yeah.
Yes. Yeah, I mean, we should never have that situation where we have multiple, I don't believe co-executive directors. There should always be either an active or an interim, or maybe by default. In the event of a vacancy, have general counsel assume the position until the commission designates.
So we,
So
we,
it's a certain-
to the resolution that you
Yeah.
draft on the succession or the interim positions, it's like executive director. Okay. And I guess the last item, the last of their recommendations is that we should adopt specific guidelines and procedures concerning recusal when employees of the agency believe they are potentially conflicted. I know we have had commissioners recuse, but I don't know that do we have any specific guidelines?
I don't think so. I think the general standard is if the commissioner believes that that their participation in the matter would either create a conflict or an appearance of a conflict.
Yeah, exactly. And there is a provision governing, the two provisions governing recusal in the proposed code of conduct. One is dictated by subsection 10 of section 94 of the executive law, which requires commissioners to disclose any potential conflicts when new matters, investigative matters, are received by the commission. That's in 10B. And there is the commission upon receipt of a complaint, referral, or commencement of an investigation shall disclose to the commission any personal, professional, financial, or other direct or indirect relationships, and so on. And there's a procedure outlined there, and we've incorporated that into the proposed code of conduct recusal policy. And then there's a broader recusal policy proposed in the code of conduct.
And that's being reviewed by the legal.
That's the legal committee that's been working on that, yes.
Right. That completes our discussion today of the Hogan-Lovells recommendations. So we didn't really vote on anything today, so maybe what we can do is we can come up with some of the resolutions that we've talked about and vote on them at a subsequent meeting and then have them get into the commission, assuming we adopt. We agree.
Sure.
Now, the next item, going to defer, was it's actually being discussed in the legal committee. Ex-Parte communication between commissioners and the appointing authority.
I'm sorry, where are you, Seymour?
Sorry. Number 4, the ex-parte communications between commissioners and appointing authority. I was reminded this morning that in fact that issue is being discussed and still under consideration by the legal committee. So it would make sense for us to be delving into that at this point. Although we might want to weigh in, even though it's not on the list, might want to weigh in after you come up with your recommendations.
That's probably the wiser way to go.
And I'll point out there is a proposal. I think there's several communications policies also in the proposed commissioner code of conduct in the section on conflicts of interest.
There are a number of recommendations that came out of the public meeting. several of the recommendations apply to both ethics and legal committee. Commissioner Austin and I had a discussion, and what we decided was that the primary committee would make a recommendation and then give that recommendation to the secondary committee for their consideration. But rather than have both committees look at issues, primary committee would do so.
Right. Otherwise, you're ending up stepping on each other's toes, and you're going to get, two different results for the same effort, which makes zero sense.
But I think you had identified some of those issues in your memo to us.
Right.
This is it, that's why it was
No,
different.
there's a difference.
But I did see the.
Well, I identified several that I thought were significant. It's just, the ones that came from the public meeting here are identified by the PM.
Thank you.
I don't know how much we want to go through this today. But we could certainly start.
We included our staff's recommendations in that document as well.
I guess with respect to the outside activity approval process. Actually, that's, special committee is actually looking at that.
Right.
So maybe what we should do is we'll not address those until the special committee addresses it.
Right.
Commissioner Austin.
Right. Yes.
Well, why don't we do that to the special committee? So one of the recommendations should be a limit on campaign contributions by individuals and entities doing or seeking to do business with the state. Staff, staff says that actually is regulated by the New York State Board of Elections.
Right, I think that's outside our jurisdiction.
What is that, what number is
Number
that?
2.
I mean, I think, and I don't remember seeing it on this list, but which is a legislative change too, but I think it's interesting that there's no information about campaign contributions from lobbyists, from other people available. So I was kind of surprised that's not part of the public information available. I know somebody mentioned it at the public meeting. I thought it was an interesting, because, that's what you want to know ultimately, like where else, how else is this being done?
But the legislature has to file certain statements with regard to contributions received, et cetera. So if you wanted to know what was being paid to by a lobbyist to an assembly member, you could just go and look at the assembly members' Board of Elections filings.
Right, and I'm suggesting that we should have it in our database as well, because.
The problem is what, you're going to double the effort, and we have a staff that is limited, and it's readily available.
If we could just add a button to that website. For me, and maybe I'm not that resourceful, but I was like, I don't know where this is. in terms of when I'm looking at lobbyists in particular. So I think it's important information, and yes, I guess people like you, Len, could find it. I'm teasing, not that I couldn't find it, but I just think it's important for us to have that information. Like a complete picture, it's a complete picture for us as public.
Maybe we should talk to communications committee about that. That's what's on the website.
Okay.
Maybe it's the right church and just the wrong pew.
And so,
Yeah,
so Dolly, you restate what it is that you.
I think it's important to have all that information in one place, and I think ours is the place that it should be. I think information about campaign contributions as well, by lobbyists, clients, yeah.
Well, just as a question, do you mean that lobbyists should be required to include that with their filings with us, or that we should independently be collecting that information from the Board of Elections? Because, the latter, as Mr.
Like
Alkin
the
has
sport.
pointed.
Again, Sandy, I'm sorry, would you repeat that?
Yeah, I was just asking Commissioner Caraballo if she means that the agencies should be independently collecting that information as from the, Board of Elections, going through that data, or that lobbyists should be required to provide that information, file that information with us themselves.
Ladder. Yeah.
Okay. Yes, I think that requires a legislative change. Because I believe, I don't want to speak for the lobbying group on this, I could be wrong. But I think campaign contributions were not included either in the gift regulations or otherwise required at this time. I think that's why those legislative proposals are there.
Actually, that probably falls under the jurisdiction of the lobbying committee.
I think it's an ethical issue myself.
It is an ethics issue, right? But it
Because
directly
lobbying is
implicates lobbying processes.
right, and what they collect. I mean, I have something maybe to have on, in a future proposal once we have all of this under control. But I like I think it's a good idea. I did hear it as well after I put it. All right, so are we going to speak to lobbying about that?
I think it's on a list for lobbying to consider.
Oh, is it? Okay. Yes, sir. Okay, so I know it was saying it, so I'm sure it's here because everything is here.
Yeah.
Should be comprehensive.
So I think the lobbying committee.
Okay, good, all right.
Another item that was raised is should the financial disclosure filings of candidates with statewide elected position legislation be posted on the website?
What number is that?
5. I think that would require legislative change.
I think so.
Yeah.
And again, if it's filed someplace and available to the public, why put ourselves to the efforts to be dealing with stuff that's already there?
Is it available to the public?
I think FDSs are available to the public by a Freedom of Information request to OCA.
But do candidates state for positions for legislature and state law?
I mean, it's true that, once the FDS is filed, it can be requested pursuant to, it can just be requested and it'll be produced. And the question is, should candidates' FDSs be publicly posted on their website for easier access the same way FDSs are for elected officials. I mean, I can see a benefit to that in making it, more accessible. But again, I think it would require legislative action.
There's also, I mean, as I understand it from our director of communications, there's a fair amount of effort that goes into going through them and preparing them and getting them up on the website. It's not apparently just a question of, sort of pasting them up there. And as with the members of the legislatures, FDS is posting them. It takes a fair amount of work. So that has to be factored into the caseload. And as has been said, if anybody's interested in looking at a candidate, all they have to do is make the request. There was the information is available to the resources and funding to support the posting.
Are there any times, Sandy or Michael, that we have situations where in an investigation, we look to what has been filed by the Board of Elections or to another agency as part of our investigation?
How often do we do that?
Is it done?
Yes.
So we know where to find it, they know where to find us.
Yes.
So,
Yes.
I mean, so my point really is, I'm not sure, Dolly, it's worth the time and effort to be creating something for us to tell people about when it's already there for them to know. It's just my thought.
So, well, I mean, I can see this thing. If a candidate or a city legislature is running for office, and that person's financial disclosure form is available, it seems only fair that the person who's challenging them should also have their financial disclosure available.
I'm thinking that maybe Commissioner Caballo is right from the perspective that perhaps what we might do is have on our webpage, if you are looking for, and give them a link. You're in the wrong place, but this is where you go.
Is that information available on the Board of Elections website?
I believe it is. I'm not sure.
Candidates? Listen,
Their financial disclosure statement, they're filed first with the LEC, and then the LEC conducts whatever preliminary review that they may conduct, and then they come over here, just as those for the electeds are filed first with the LEC, and then come to us. And then we're the body to which the request is made, typically.
It's the request to view it.
Okay.
the request goes first to,
The FDS itself is filed with the LEC.
okay.
And they take it and review it, and then they forward it to us, and then we're like the keepers of the FDSs, and we're the ones who someone would approach if they wanted to obtain a copy.
This goes to that issue we were talking about in communications already about what's going to be available on our website.
I think that probably is communication next.
Is that the one that got changed? We weren't primary on that. The communications was. Post candidate is on page 1. Disclosures.
That wasn't.
Yeah. But I think it is, well, what we are talking about in communications about, how to expand the website to And we should, so that there's less FOIL requests on certain things.
So then I guess what we need to determine whether we feel it should be there. And then we need to consult communications as to the feasibility.
So we have it already, so those are usually subject to FOIL, right?
Right. I mean,
And
a lot of work is involved in posting the FDSs on the website because, all redactions have to be done, before they're posted.
Right.
The benefit of, from our perspective of not posting them and allowing people to request them one at a time is that those redactions can then be done only when necessary and one at a time.
and then you keep that redacted.
And you'd have 5 candidates per position, you'd have to redact all those for one minute.
Right.
Okay, I mean, well, I guess it's something to think about lately, like, again, how can.
If they triple our budget.
Sure.
The problem, Dolly, is that, a lot of it is not just it's the filing by legislators and judicial candidates is not merely for the purpose of ethics, but for the purpose of other information that could be available for the purposes of election law claims and various other things. So I don't know that we want to venture into territory where we're stepping on others' toes in that regard. I'm not sure I would want the commission's records being part of an election law claim, whatever it may be. So that's my thought.
So I guess at this point, we're not in a position to say that we want to do that.
Say that's right.
Is incorrect. Just trying to,
Would be the immense amount of work.
yeah, like, I mean, hopefully we'll have better technology and whatever, it's something, and make it easier, but that's fine. And then I understand why after it's requested once, it's not even an issue anymore.
Right.
So,
The next item that been identified for us is the commission staff, not the legislative ethics commission, required directly of a legislator whenever filing disclosed interests that appear to conflict with or compromise independent judgment. That would require us to go through these things in detail.
It would make us the reviewer in the first instance of all legislators' FDSs. And right now they file with the LEC in the first instance. So the LEC would be in the position of collecting the FDSs, sending them to us to review before they've reviewed them.
I think we should leave that.
Yeah.
as-
We should leave it to LEC. You agree, Commissioner Austin?
Yeah, I think that's the way it should be. I think it's out of our realm.
Next item, should call to support an amendment to the state constitution to establish a code of ethics enforced by an independently appointed commission. Last year's state commission on judicial conduct. We have-
Be taken up with legal, I think, like those are part of the code of conduct.
It would be part of the code of conduct. This recommendation refers to a code of ethics, which the state already has effectively. That's Public Officers Law 74. And I don't really have a position on the rest of that.
Yeah, they suggest there should be a constitutional amendment authorizing public.
I think they're talking about establishing a different commission altogether. When I refer to an independent commission, I think they're distinguishing that.
I think, there's been some discussion, some folks recommend that an independent commission. Some people say we're too independent. That none of the members of the commission should be appointed by any of the elected officials.
That's the idea, yeah.
Right, yeah.
I don't think that's our bailiwick.
There's problems with that too.
That's purely a legislative issue.
Last thing I want to address today is should call support legislation by members of Regional Economic Development Council. Financial disclosure statements be subject to freedom of information on the open meetings law. Can you
Sounds like it's
explain that?
within-
My understanding is that the regional economic development boards, receive certain amounts of money, and then their remit is to promote economic development in the regions that they are responsible for. I think there's an argument to be made that because they're responsible for giving out funds, there's an argument to be made that they should but I don't want to make a definitive statement before I think we looked into it further. Yeah.
So let's on decision on whether we think we should do this. Let's look into it for
We can look into this.
a little more now.
Let us know.
I mean, people could be contributing to them in order to get them to
Exactly.
provide money.
They could be giving money in exchange for to themselves. Not to say that that's happened, but that possibility is there.
Right. Yeah, that's interesting.
Right, I think that as concludes the ones that we've identified for today, there are other items on there. Other recommendations I think we probably should consider. Under new business, I guess we're going to talk about the fact that we are going to be undertaking an advisory opinion review, and I think the special committee is going to be taking a look at that, up with a procedure for us to go through the advisory opinions, and I guess once we have that procedure established, our committee may get some of that responsibility, and then we'll talk about how we want to move forward at that time.
Right.
Is there any other new business?
Of this.
Except for their-
The decisions like are interesting, like to look into whether they're wrong. I know it's this part of this committee, but something seemed more immediate than others. I
Which
heard you mention that before.
Right. Which one did you think we should pick?
There's two bar, the number 5, which is staff proposed subjects of the holding an advisory opinion that the 2-year bar completely prohibits a former employee of the state insurance fund from representing a client before the SIF incorrectly applies a so-called litigation exception to the 2-year bar. And I guess you're saying that's something that is not, it's just.
That's an inconsistency that I've identified. It's actually one of the few, maybe the only inconsistency that I've identified.
Okay. And you mentioned, yes.
Yeah, I have mentioned that in the past.
Yeah.
I don't think it's necessarily a priority that needs to be addressed immediately because there are lots of other advisory opinions that address the same concept of the litigation exception. And this one only refers to a single agency, and it's specific to that agency.
So it's not that.
And we know it's wrong. So, yeah.
Okay, so I guess the ad hoc committee can take that up as what, the full review, to do that. Ava's gonna be starting with. What other? Data mining opportunities and restrictions. I don't know if that's something communication would be taken.
I think,
Yeah. It's like a, like, but I think that's, you know, it's good to have as much information. Okay, so that would be. And so that's the only one that you identify, huh?
That's the only one that I'm aware of, yes. I mean, I don't, the entire so-called litigation exception subject is something that might want to be revisited at some point, but I don't think it's inconsistent with anything else. I just think it might be revisited on its own merits.
And so right now, the way, so that's a 13 case. So that doesn't mean we decided it, but it would only apply to that particular agency.
And I'm not concerned that we would feel constrained to follow that as precedent. If something came up, because we have other advisory opinions and we know that this one is not accurate. The only like real downside is that it's out there listed on our website.
Yeah.
Right, so at some point we should address it.
Yeah, because if somebody looks at it and relies on it, it causes, yeah, I think that's right. But that, and if it's a state fund, state insurance fund employee, then it's sort of like it is binding.
Right, but we,
right to say.
I'm saying, like, we wouldn't.
It wouldn't happen.
Yeah.
But they would be, it would be a reasonable reliance.
If they
did something.
If they looked it up themselves and then they made their own conclusion and didn't contact us, that would be unfortunate. Right, that's what I'm.
Right, I mean, and they would be reasonable in that assumption, right? So, okay. And it is on the website, so we should think about that. And this might be something, new business, the emails. And it's ethical too, because it is a question of security, right? Is it like should we discuss whether like to encourage everyone to get on it, or it's like it's just sort of we have it available. There has been no further statement about why it's important to have this particular, use that for our, confidential communications. So that's what we want to talk about.
You're talking about using state email?
Yes. Yes.
Yeah, among other things, it's secure. For example, using Gmail does not provide the level of security that we would like and feel comfortable with respect to certain kinds of communications. It's also easier securely to use or secure SharePoint platforms if you're using state email. We can give you easier access, if you will, to the SharePoint site using state email. Nobody is able to drop in or try to use email communications for advertising purposes or any other ancillary things if you're using state email.
Yeah, I don't think any statement has been really made to us about it, to kind of, I think to myself, oh boy, am I going to miss emails because I'm used to my email popping up, which isn't secure, but I kind of think it's important for us. And I think maybe a statement should be made about it.
I don't think it's in my jurisdiction. It's probably administration.
Yeah, or maybe just, I think
The-
we just do an email or do an email to everyone saying, or communications director. I just think I don't think I think we should pay more attention to it, is all I'm saying. And I think everyone should be
Right.
told, I think we're highly encouraging you to do this for security purposes. And I'm just suggesting we do that, just to move it forward and get your figure.
Yeah, I don't have the knowledge to opine on.
Okay, so, but, yes, just.
Yeah, and well, that's me. I'm not, an expert on that either. But what
Same
we
with
were
the
told
chair,
was-
maybe the chair. I'm just raising
All
it
I'm
as
saying
an
is, I don't think it's within. this
our
is-
ethics committee, okay.
But it certainly suggests that you may want to make to your day.
Okay.
I think I'm scheduled for my training tomorrow.
Yeah, once you get accustomed to it and you have it, on your phone, when you're using the RSA security, it's not difficult to use. It also makes things easier when FOIL requests come in and those sorts of things, because your email's segregated in a separate place. So
I will sign on.
You have it scheduled yet?
No.
What are you going to do?
No, I know. I've done, I did a couple of the trainings online, but not that.
All right.
They're not, you're doing a live.
I think it's live, so oh my God.
Live online?
So
Um,
it's online. All right, there being no further business, I entertain a motion to adjourn.
So moved.
Second, okay.
Yeah.
All right. All right, everybody in favor of, okay, there we go. Thank you.
all right, thank you so much.
Thank you,
All right,
Steve.
very well. Good. Thank you.
Have a-